You talking to me random. You talking to me like I'm on the street. You talking to me like I ran into you in the neighborhood. You talking to me like I'm not Judge Lenise Bryant. See?
On behalf of Ms. Wilson, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Judge, it's the first scheduling of the pretrial conference. I'm going to ask the court to adjourn the pretrial conference to give the complaining witness one more opportunity to...
Before things spiral, here's something worth noticing. Courtrooms don't just run on facts, they run on procedure. Even a simple question about who represents whom can affect the entire hearing. But pay close attention to Miss Wilson's demeanor from this point forward, because in court, first impressions can influence how every word is received. Do you think attitude should ever impact a judge's decisions, or should only the legal facts matter? Let us know below.
Here, and Your Honor, for the court's information, the second defendant was scheduled for August 17th.
Sound off below. Legal minds want to know.
For an adjourned pretrial conference.
Who was the co-defendant on Wilson?
Miss Haley.
Oh, okay.
Under 830.
So, Ms. Stevenson, did you all represent Ms. Haley?
I have, my note indicates that Ms. Haley should be here as well. Just 1 second, Judge.
Both here. I already did Ms. Haley's. Ma'am, put your...
Oh, I'm sorry. Okay.
Text and stuff while we in court.
Okay, thank you for that information, Your Honor. In that, and Ms. Haley was defendant number 2. Our normal practice is to request that the court appoint counsel for for subsequent defendants. So we usually take defendant number 1, Your Honor. So I will leave that to the court's discretion as to which of these defendants we should represent.
I was waiting to see, I was just waiting. I was wondering if Ms. Wilson was going to unmute herself and apologize.
So, this is where the temperature in the courtroom changes instantly. Mentioning a job interview instead of focusing on a scheduled court appearance is almost guaranteed to raise eyebrows. Judges expect court to be the top priority unless there's an emergency or prior approval. What started as an explanation is quickly sounding like an excuse, and Judge Bryant isn't buying it.
To the court.
I'm sorry. I just picked my phone up. I have an interview to be at. I'm not going to be able to make it, so.
And apparently you blaming that on me.
No, ma'am.
Well, your attitude sucks. You talking to me random. You talking to me like I'm on the street.
Here it is, the explosion. Miss Wilson casually mentioned she have you.
You talking to me like I ran into you in the neighborhood. You talking to me like I'm not Judge Lenise Bryant. So the fact that you scheduled an interview on the same day that you had court, that sounds like a poor choice and a bad decision. That sounds like a poor choice and a bad decision.
I do not schedule
what you're not going to do is come into my courtroom and be disrespectful. That apology was, I guess I shouldn't have even mentioned it because it certainly wasn't sincere. So let me just help you with something. You can continue to come to my courtroom with a bad attitude, and it's only going to...
This isn't just a lecture, it's a warning. Notice that Judge Bryant keeps giving Miss Wilson opportunities to reset her attitude instead of immediately punishing her. That's actually more common than people realize. Many judges prefer voluntary compliance before resorting to contempt. The real question is, if someone realizes they've upset the judge, is it better to keep explaining or simply apologize and stop talking?
Work out poorly for you. It's not going to work out poorly for me. It's only going to work out poorly for you. So when one has court, then you have to understand that court could take I'm not even going to continue because she is really on her way to contempt. She is really on her way to contempt. So let's go ahead and let her come in person. Okay. We're going to come in person.
Now the consequences become very real. A higher bond and GPS monitoring aren't designed to punish someone's attitude alone. They're meant to increase the likelihood that the defendant appears for future hearings. But when repeated courtroom behavior raises concerns about compliance, judges may decide stronger conditions are necessary. At this point, this hearing has gone far beyond where it started.
So the court is going to adjourn Ms. Wilson's pretrial conference to next week. She's going to come in person. I'm going to set the matter for 8:34. She's going to come in person on let's see, today. Oh, that's today. So we're going to come in person on Monday, July the 24th. And we're going to come at 8:34.
Your Honor.
24th. At 8:34. Failure to appear is going to result in the bond being revoked, court issuing a capias, and the court is going to set the bond in the amount of $5,000 cash surety plus a GPS tether. Is there anything else for the record?
My mother has an appointment on Monday. She just had knee surgery, and I have to drive her at 8:30 in the morning.
Okay, well, I mean, we all have to make choices. Is there anything else for the record? Because we wouldn't be dealing with the mother surgery if you was respectful today. So if you didn't come on my court today with your stanky attitude, if you didn't come on my court today with your disrespectful disposition, if you didn't come on my court today with your rude behavior, then it wouldn't even be an issue about your mother surgery. Wouldn't even be an issue about your mother surgery. So you're rude and disrespectful, Miss Wilson. You're rude and disrespectful. And the fact that you're talking right now shows me how rude and disrespectful you are. You have no contriteness about yourself. You have no humility about yourself. You're simply rude and disrespectful to the court. But there's never going to be a day that I allow you to come to my job.
This is one of those moments where courtroom authority takes center stage. Contempt of court isn't about bruised feelings. It's about protecting the court's ability to function. If participants constantly interrupt or ignore instructions, the legal process breaks down. Whether you agree with Judge Bryant's tone or not, she's making it crystal clear that respect for the courtroom isn't optional. Was this tough but fair, or too harsh?
And be rude and disrespectful to me without consequence. You're rude. You're disrespectful. I didn't charge you with the crime. I didn't set your court date for today. I showed up for work. And when I got up this morning to show up for work, I didn't say, let me put on a robe so Miss Wilson can be rude and disrespectful. Ms. Stevenson, I'm going to send Ms. Wilson back to the breakout room because if she say one more thing to me in her tone, she going to jail. So I'm going to let her tell you about her mother. Because if she says one more thing to me in that tone, she's going to jail.
Okay.
There is an appropriate and respectful way to ask the court. If you turn your head from me one more time, I'm going to hold you in contempt. I promise you. I make a promise to you. We're going to take a recess. No, Miss Modrick, come on camera. I won't recess before I let you get discharged. Come on camera.
What an incredible courtroom showdown. One hearing, one attitude, and the entire outcome changed dramatically. Whether you believe Judge Bryant was exactly right or think she was too strict, this case proves one thing. How you conduct yourself in court can matter almost as much as the legal issue you're there to resolve. If you learned something from this breakdown, tell us your biggest takeaway in the comments. And don't forget to subscribe for more courtroom analysis. And the consequences stack fast. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more fire coming your way. Stay tuned.